Namaskar everyone. Welcome to our episode, the new episode of our channel See You Soon. And today I bring you a very special guest from Bengaluru City, Mr. Kumar Sambasivan. He is the General Counsel of one of the leading companies in India, Kamesha Renewables Private Limited. Mr. Kumar.
Sorry, Jayant.
Sorry, I stand corrected of INR Renewable Company. And Mr. Sambasivan had a great career spanning over more than 3 decades. And in our journey, in our chat today, we are going to discuss his journey of these 3 decades and try to, trace as much of, his wisdom as possible, both from his legal journey and from his personal journey. I welcome you, sir, to our program. Thank you very much for sparing your valuable time and coming on this platform to be with our viewers and be with us and sharing your great journey with us. As a matter of practice and tradition of this channel, I always start asking our esteemed guests about how they started their life, their formal education before they were lawyers. And what was that moment in your life when you decided that I must pursue law as a career and I must become a lawyer and then contribute to the society? Over to you, sir.
Okay. Let me give me a idea of before start my education, before give me a idea of how I started all along my education up to 12th standard has always been in vernacular. Okay, in the state of Tamil Nadu, I born and brought up in a village. Okay, so till 12th standard, and of course the graduation and post graduation BCom and MCom happened to be unique. So that was at that time it was a challenge. So then once I overcome the challenge, then I went and after did my MCom. I was more my idea was more tuned towards CA, but my handicap was I was not that great in mathematics. Okay. So then I looked at it where I can look I can at least use my speaking skills to the maximum. That was the idea. Where I thought that was the first time when the Madras Law College announced a competitive exam for the law entrance exams. So that way, that was my first batch, and I casually went in and then applied for it, and then out of 3 choices, I applied for Madras Law College, Madras Law College, and Madras Law College. Those 3 choices, and I didn't give any choice because if I don't get it in Madras Law College, I don't want to study anywhere else. So then that was the idea, and luckily I got that. So then that started me in law. Then after that, I've studied 3 years in Madras Law College. The campus is next to the High Court of Madras, so that we had great opportunities of most of the options. I think we utilized it well in the sense the college we usually attend, even though it is college is there in the afternoon, we spend a lot of time in the court. That gave us enough idea of like how, especially in the lower courts, we spent a lot of time in the trial courts. So that gave us a lot of idea on, say, starting from filing to the matter appearance of very senior counsel. So that gave me an inspiration that, because especially considering I don't have anybody in the family who can support me, how no one in the family doing law. And it was a family of agriculturists to be precise. So that being the case, it was a challenge to sustain. I joined immediately after I enrolled in the bar. I joined the office of Mr. A.C. Mukana Senior Counsel. Was practicing on the original side substantially. And so I was there for a couple of years. Then through a recommendation from my office, I joined the corporate office after a couple of years. So it was basically from my office, I was more a secondment at the start, and then I went on continued work. Then it started, I joined a company called TTK in 92, I think, 1992. Then after that, that was a great introduction because I was at the start their legal department, and then I got opportunities of doing anything and everything. I was given a lot of freedom to experiment. I have made mistakes, and uh, I had corrected myself. So that was a great learning experience, starting from civil matters to corporate, then intellectual property, then joint ventures, then anything, and even economic offences. So it was a conglomerate of several things: pharmaceutical, pharmacy, taxes. So it was time to at least get introduced the various facets of law. So that way, yeah, advantage. I have a distinct advantage in the sense. See, at least I could sense if some topic was then I can understand the relevance of it. If not, I don't have a in-depth knowledge of it, but at least I can place. So that somebody like who talking in a patent law, I can place this at least comes in a patent law subject, or this comes in a different. So that way, that gives me a different thing. But however, my focus after some years, I continued there for 7, 8 years. But my focus interest in contract law took me to a lot of things, because I thought this is going to be my career in contracts. So the best place to look at it or further it my interest, I thought I decided that a infrastructure company is the most suited, because the entire company runs on contracts. So that way I joined another growing company at that time, which is GMR.
Right. So may I just, with your permission,
yeah, please,
pause you here, and because I'm going to cover this journey in detail. But okay. you very interestingly told us about your journey from hailing from a village, then studying law in Madras Law College. And if I'm not wrong, that we are speaking of late 80s, because I think it was in 1990 when you completed law and graduated.
Absolutely.
Right.
Absolutely. So 90 I completed. 97, 90 is my law.
Right. So 1990, you are a fresh graduate out of law school. Let's go back to your law school life. Let me refresh certain memories, because many of our viewers are young lawyers, budding lawyers studying in law school. So how different was studying law in the late 80s? Number one. Number two, were there any concept of internships back in those days, or moot courts, or these United Nations conventions, all those things which we hear today? And if not, then how would you get a guidance back in the late 80s to decide what you have to do as a lawyer?
Okay, very probing question to be answered. In the sense, there was nobody, as I said earlier, there was no one in the family to handle. And another thing, I didn't have anyone in the anyone near and dear ones who in practice also there to handle. So it is all spent for yourself time. So that way, I know that after I came to know that even the subjects after I started off the law college. So I didn't know what the subjects are. So I started off. Then after I started off, then I had an interest developed in a few subjects. So slowly, in the sense, maybe it's due to the professors there. It may be one of the reasons. And it's also one of the reasons where the exposure of the college being closer to the High Court, where you can see great lawyers coming and arguing. At least if not, you don't understand the subject, at least the way in which they argue, the confidence they have, the way in which they have countered the opposite side. That gives you an impression, at least let them emulate to an extent. That gave me a lot of inspiration, I would say. And so I thought, okay, at that time there were doyens in that place. You can see even my senior was again a tall figure in the original side. And at that time, Mr. Aryama Sundaram was there in arguing in court. Then Mr. Arvind Datta. So these are all tall figures at that time. And of course, there are several senior counsel. And Mr. Sundaram at that time was not a designated senior counsel. So these are all people whom we have admired at that point of time, with the way youngsters were able to argue well, and they were looking at, because these are Mr. Sundaram and his daughter. That's quite young, 30 years back. Yeah, so these are all things which we inspired, and yes, we should do something significant.
Right. And sir, because when I speak to a lot of law students today, uh, uh,
Mhm.
in this new millennia, so as to say, some of them are very confused, especially with the 5-year law course. Some people, I think, having a midlife crisis in the 3rd year of law school when they are deciding to drop out of law. So, was it ever a time when you were studying law, being a first generation lawyer, did you ever think that it's a tough field? I don't know, because in late 80s, so far as my limited understanding goes, the whole culture, the whole corporate culture was not there. Yes, in 90s we started to have a liberalization, everything. But did it ever occur to your mind that I should leave law or I should pursue law as a proper career and let's see what happens?
No, I think the initial idea was that is to practice law. But it was, as you said rightly, there was no clear distinction of, especially in a place like uh, Madras, to be precise, at that point of time. Now only it is Chennai. At that point of time, yeah. So there was no clear distinction between a civil lawyer, criminal lawyer, corporate lawyer, or intellectual property lawyer, whatever you can call it. It's all, end of the day, a lawyer. So that being the case, so the major distinction seems to be, at least at the High Court level, a civil lawyer and a criminal lawyer. That's it. Nothing more than that. Probably there is no further distinction. Everybody is specialized to do everything that way. So there was nothing. There was no hand-holding from the college, to be honest, and there was nothing to be. All this moot court and all came in a couple of years later. So there was no real experience of being there. But one experience, as I said earlier, we had looked at people who are there on the ground. In the sense, say like, slowly when we are regular in the High Court, we get to know some of the seniors. So then we try to tag on with them wherever they go. So they also encourage that in a indirect way, but there is nothing formal about it. So there was no internship which was there. Absolutely, as you said, nothing of that sort. So we were just dazed and confused at that point of time. I would put it on.
Sir, you very nicely narrated that the doyens of the bar, and if I may be so frank to say that we draw inspiration and benefit from them. Both Mr. Sundaram and Mr. Dattar, who are eminent senior lawyers of the country, have now shifted their base to Supreme Court. And sometimes being in Delhi, I think has its own advantage that you can see them. And I hope with the digitization coming our way, people across the country should benefit from so many seniors, across the platform, because we have such gems in the country, and I think the legal fraternity and even the people who are not lawyers can benefit from such nuggets of wisdom, which falls from some of the eminent lawyers in the country. So let me now come to the phase when you started your career as a lawyer, and you say you joined an eminent senior at the bar in Madras those days. Now we call it Chennai, obviously. How was your experience starting as a young lawyer? How stressful was your life as a young lawyer? Because one, you are a first generation lawyer, just finished law, joining a senior, and you said in those days, as opposed to now, there was not a specialist practice, so a lawyer was a lawyer. So how was that experience? If you can share some light in your early years, in the early 90s.
Okay. At least, Mr. In one of the at that point of time, Mr. A.C. Muthana's office was one of the well-organized office, I would say. I was fortunate to join it. It was one of the well-organized office, and a substantial practice was on the women's side. So, and maybe some of repetition, but substantially from women's side. So that way, and immediately after joining, my first job was I was tagged along with the court clerk. Okay. So
Which is always very
the
important.
first, this is very, very important. Till today, I know that how to stitch a court paper with thread. so to that extent, I was trained in the sense every section, then filing, then how to remove the objections raised by the court section. Then and thanks to the very experienced court clerks who are there for at least 20, 30 years in the same office, they know in and out of them, and they know how to even draft petitions. to that extent, right? They're well experienced, well-oiled machine. So that way I was handhold and where to file, what are the timelines and when to file, all these things. 3 months I spent in the court section, to be very honest. And then then I started appearing in the by default whenever there is a lawyer not there. So you have to go and take an adjournment. This continued for 2. And then fortunately, since I was little confident, maybe cocky, I would say, that then I asked for some lawyers who are little juniors in the sense, at least senior to me. And they said, can I take something little more chances with the court? That's how it started, where I started arguing. In the sense, say, small matters, then where I started arguing in the small causes court, rent court, etc., etc., where the seniors were at least to that extent, they were very big. What you can do? If at all you miss a matter, we can always correct in the appeal. So they were quite liberal in the sense. They said we can always correct it. You argue the matter. So all the interim applications I argued. So was quite successful in that way. Some of them. So and say whatever when some of the seniors didn't want to argue against some of the lawyers which they come up on the other side, so they placed me like a rookie over there. Then I was so this is all I have and in fact I had a pleasant memory of uh, being arguing before very great judges who encourage juniors. So I would like to this thing. In fact, I think one of the earlier days, I think I remember Justice Ratnam. I was appearing before in a second appeal in a criminal matter. Okay, I was a junior, hardly 2 years in bar, so I was pushed into that. In the sense, I was taken a brief, and then I was standing over there just for my senior to come in, and uh, it is our appeal. So the judge said, "You start." So at least I read the brief. I started. I was hesitant. I waited for my senior. But that said nothing. You go ahead. Then he was asking me. Actually, the judge was very, innocent, very supportive of me. He said, "I know what are all cases. Is it what you are going to cite?" It was very supportive. And then incidentally, my senior walks in. So, and then I try to move in, and says that the judge says that Mr. Mustafa, your juniors doing reasonably well. Why you don't want to stop the flow? So these are all something very great judges that time. I would say that where uh, you are you feel that you are on a much higher pedestal. I would put it that way. So that way it was very supportive, and these are all confidences which gave me, I will remember for a lifetime.
Very nicely put. Because this is, I think it's something even I firmly believe that a few years in litigation always helps you gain a firm grounding, and especially I think the time spent with the court clerk is indispensable. I think at least in our industry, because that gives you an overall view of how the profession actually runs. Because he has the bird's eye view, he has the vantage point, so as to say. Now, so we are talking of early 1990s, the decade which also saw liberalization in the country, and that is also the time when you made your move from being a litigation counsel to being an in-house counsel, and you joined TTK Group, and you spent substantial time there, about 7 years, if I'm not wrong. So please tell me, sir, how was that transition? What prompted you to have that transition from being a litigator to an in-house counsel? And compared to today, when you are general counsel, when you're heading a team, did back in those days, these companies used to have big legal teams, or how was it any different from, let's say, 2021 compared to a 1990 in-house market?
Okay. I would put it that way. In the sense, for that company, I was two people joined together. So, two legal members of the team. One was doing a separate area, and I was looking at all other things. So it was like, for us, the company, they had the first legal counsel as in-house counsel. Earlier, they were going to external law. So we were the first in-house legal team. So both of us were the company as well as we were to find ourselves something to understand how to organize ourselves. So that way it was a great learning experience. So everything, especially what is important is that more than external stakeholders, whether it is outside the company, the internal stakeholders are much more critical. They can make them reasonably comfortable that you are there for them. So that way, the confidence building measures are much more critical. So that's what the first step took. It took quite some time where understand their expectations and their ability to come up with solutions which can suit them without going on the wrong side of the law. So that is very critical. Because being a in-house counsel, it is always you should always remember that you continue to remain an officer of the court or the something where whether you are being a lawyer by profession or being a intelligent counsel, you can never afford to break the law or bend the law, whatever it is you are doing. But unfortunately, today the scenario is a little changing in the sense. Say, I see a lot of counsel are accustomed to whatever the bosses say is right, which is not correct. So you should ensure that you cannot afford to break the law. That is always rule number one, rule number two, and rule number three. So that way. Fortunately, I had a great boss there. So that way, he was very supportive, and also gave me a lot of freedom to experiment and also to look at and whatever I could do it on my own, and also where I could not do it on my own, I have a great counsel. So that way, in-house counsel has a different advantage of engaging in outside counsel. So that way, and of course, a variety of subjects as the liberalization opened up at that point of time, post 92, 93 onward. So it gives several economic opportunities for companies to grow up and also expand operations and also grow in different fields. So these are all things which have happened. Do you have any questions?
Right, sir. So you were mentioning in the opening remark when you're talking about TTK Group that you had the opportunity to work in different verticals of this company. I have two questions. What were those verticals, and which was your favorite vertical as a lawyer to work on?
Okay. So again, what is happening? TTK had different products. In the sense, TTK, the primary company has been the TTK Prestige, which manufactures pressure. Okay. So that is more of a FMCG or the fast-moving consumer goods. Okay. So that is one section. Then they had a TTK pharma at that time. Now it is called TTK Healthcare, which is into pharmaceutical product, bulk chemical, and also they had a pharma division. So these are 2-3 things. Then they had a condom manufacturing, which is called TTK Ltd. They had a condom manufacturing, and they had a cartographic division. They have paper manufacturing. So each has got its own set of complications. So, for example, if there was at that time in TTK Prestige, there was a huge problem of uh, the spare parts of the product being manufactured, and so it was a huge intellectual property. So one is that it apart from being it created a negative market for the company, it also created a lot of goodwill impact, or because there were a few pressure cooker bursts because of the use of spurious spare parts. So that way we were able to successfully put down that fire over a period of a couple of years, so that that market was killed. Then of course there were technological improvements in the issue. That's a different thing. But yes, so there was, and also there was consumer complaints and addressing it. So to the extent of from district consumer court to Supreme Court escalations. So to that extent. Then there were issues relating to where you can recover from dealers who are civil recovery cases, whatever, and taxes. You have at that time there was more of centralized sales tax. So various facets of law, which is apart from that, there were the company was into joint venture with a few companies, so there was joint venture issue. Then apart from that, there were corporate economic offenses. There were some issue, and minor issues like even you can say that the standardized weights and measures, which the authorities used to actually hold you in ransom. I would put it that way. So, which is very much misused by several departments wherein you are at some remotest possibility they may, because they had a list of directors. So they will file a case in the local court and send you a non-bailable warrant to all your life. So that way, how to handle that? And see, because I was so used to firefighting, now firefighting comes naturally. So that is the distinct advantage because it gives you a preparedness at any point of time without the ability to, without getting disturbed by the situation. Because if somebody today's scenario is that for a young lawyer, yeah, for a director and NBW has been served in the morning, which means you get disturbed mentally. But for me, it is because I was got used to that scenario much earlier. Okay, it is only an NBW, nothing more than that, right? So you see the next step. So that gives us this slight advantage. I would put that. Then apart from that, in TTK Healthcare, we have pharmaceuticals. So it has got its own product, drug prices control order. Then you have the trademark, a lot of trademarks to be registered for the company. Because it is in pharmaceuticals. Then there are there's like each vertical and there were condom manufacturing. There were so many issues, and interestingly there were quite consumer complaints relating to condom manufacturing as well.
Maybe population burst. It's one of the reasons. Even malfunction.
No. It's very interesting, but probably not the right forum to share this, but very interesting remarks and complaints which are large. See, I can one civilized one. I can say that somebody said like, oh, there was a defect in the condom. So when he was using it, so he got a kit out of that, and he said that he has filed a complaint saying that you have to pay me for a few lakhs rupees at that point of time till that kid studies MBBS.
Wow.
Okay, this is coming out of something a complaint out of Malappuram in Kerala.
Because of a defective contraceptive.
Yeah, it's a product which has cost me with a kid, and I got a kid which I don't want, and very well you pay for it.
It's basically the company is responsible for any malfunction
so
and for the offspring thereafter.
It's a company-sponsored child. I would put it that way.
Sir, if I may ask, did the company actually sponsor that child, or did you manage to win that legal battle?
No. We asked him some uncomfortable questions see, I told him, if I am there, this thing on cross-examination, we'll ask your wife a few uncomfortable questions. Would you want that? So the best case, we said like, no, we gave him a freshly minted a pack of condoms, and that's it. You do what you want.
It's difficult to prove in a court of law if there was actually a defect in the product or not. It's very tough to prove.
No. How to prove the nexus?
Correct.
So I put it more civilly.
So I would say the company, sir, was in good hands when you are championing the cause of TTK Legal. And after that phase of TTK, you moved to GMR, is what I understand. And you also spent considerable time, about half a decade, 5 years in that company. Please tell me, sir, how was that experience different from your first in-house job?
Okay, again, I was fortunate enough in GMR as well, since I was the first in-house counsel there as well. Okay, so it was the time when GMR has started a journey of being in the infrastructure industry. Traditionally, they come from a manufacturing industry. And this was the first time they got into the PPP, that is the public-private partnership model. So that way they started their first power project in Chennai. Then they started their second power project out of Mangalore in Karnataka. So it was a very interesting journey in the sense I know how contracts can run the company. How see, I have never seen in my earlier days a contract beyond 40 pages. For the first time, I am seeing a contract which runs into 300, 400 pages. So literally amazed, I would say that. So much detail, so much uh, in the sense, what can go wrong and what are the remedies which are good and how to claim the remedies. So these are all very interesting facts where how a contract, and I have also experienced how a contract can be uh, taken abused by the government. In the sense, when we are especially in a PPP model, the government is always on the other side. And the government, how they take it for granted, how they don't have a respect for the contract. So, what are your as entrepreneur or a developer? What are your rights at that point of time? How to agitate it, and at what point of time you have to agitate, and without uh, disturbing your regular business in the sense. You have to maintain a relationship, but at the same time you have to assert your rights. How to do? Because this is very, very critical. So you have to have the relationship going. At the same time, you have to assert your rights. That's where the question of contract management comes. So you need to have a knack of writing communication, and also without ruffling anything at the government, especially with the government departments, you need to be polite, but at the same time, you have to communicate your message in a very subtle form. These are all very critical skills, especially in a large infrastructure contract. And also, it is very important that you have a hang of at least your ability to go through the contract and assimilate yourself a synopsis of the contract in such a way that you are able to immediately connect any subject to critical functions of the contract. So these are all, and it also, the GMR scheme also gave me opportunities because at that time new projects were coming which nobody has come into done in India because at that time GMR bid for the project for the road projects. For the first time, NHA was auctioning the road projects in India. So that was a toll-based project, which now we see every toll. This thing. And that was for the first time it came out in somewhere in 2000. Okay. So at that point of time, yeah, any road project apart from NHA was never heard of. So that being is whether toll, how the toll will be collected, how the transport study will be made, how the economics will be worked out. So there was not much of wisdom in the country. So there were foreign consultants who were engaged. So that way you have the ability to interact with the best in the business. So these are all yeah, go ahead, please.
No, so please complete, and then I'll follow up the question.
No, that again, then apart from when the road project got done, then again the next phase was airport project. At that time, there was nothing called a private international airport. So there was only an act called Indian Aircraft Act at that time. So anything above a particular height becomes the government property. Okay. With that being the case, there was no possibility of a private international airport being possible. That being so that concern, there were consultants who were called for and worked with them to make a policy note of how to prepare a new law which will enable a new international airport being established. So these were all something very, very learning experiences.
I think sir, the few great points that I think you highlighted, and one question that I think I need to ask you out of this experience that you had in GMR is that you talked about contracts, that your initial experience as a young lawyer in dealing with contracts, and the sea change that you saw in how to one uh, evaluate a contract. And the question I have is mainly from the perspective of a young lawyer or a young law student who want to make a career in being an in-house counsel or even joining a law firm. So contract hold a lot of sanctity because that's also one of the first core subject which is taught in law school, the law of contracts and how agreements have to be understood and drafted. So sir, my first question is, are there any special courses that you think that a young law student must take to understand the drafting of a contract? And number two, do you think the contracts actually need to be so verbose, running into thousands of pages, or could they be simplified in today's day and age? Or what is your take on that?
No, I think what I feel is that the first and foremost is to I think the students or the young practitioners should be encouraged to read the Bar Act, which is I think that is where everybody reads a lot of huge text or go through a lot of judgments or do several other things. But hardly there is anything where the focus is on the Bar Act. I think the first and foremost is to read Bar Act several times. And by several times mean you need to study in a structured way that why it is done that way. What is the genesis of that particular contract? And how do they connect that? Because there are judgments. See, what happens is that every judgment you feel that it is good law today, then it gets overruled subsequently. So the judgment is good for a particular day, for a particular week, for a particular set of facts. But apart from that, but why that judgment applies to this particular thing, you have to use your own wisdom to do that, to think through that. That is very, very important. So that way, reading of first and foremost, a lot of reading time to be spent on the Bar Act. And once you do the Bar Act, I think it is important that the next set of reading material could be very landmark judgments on a contract law or on specific topic area, which may be the next level of study. But again, today the contracts are done in I think there are a lot of verbose in writing the contract, which is not required. I think a contract can be much more simplified. And in fact, if you are able to, if you have clarity in thought, there is no, and especially, unfortunately, what is happening is that every third paragraph comes with that, with the non-obstante clause, notwithstanding anything contained in it. If you keep on repeating that, then there is no sanctity to the paragraph. So, but it has become because of the copy and paste methods. So what is happening is that people copy paste everything and they take template from there, from somewhere and apply it here.
Application of mind is missing sometimes.
Application of mind is, I think there is some originality is missing, I would put that. So you need to, it cannot be something you can buy. A contract is not something ready. You have to stitch it. You have to stitch it yourself. So that way you have the happiness of what you, and think it like a lawyer in the sense I would put it put one golden word you should think that my senior said. If you want to study a contract, understand contract, you should know how to abuse it. If you know how to abuse it, then you know you will plug the right holes. So that is how I say it. You should first think how it can be abused. Correct. So think of it the ways and means of abusing it. Then you plug the holes. Then you have a contract.
Know the loopholes to understand the law, and then that is very important.
That is the thing. Where all it can go wrong. See, if you fill water everywhere, then in the bulb and it pours all the holes. You plug the holes, and then water is bound to retain it. But end of the day, it is very, very important that to contract to be, you can have an ironclad contract. But it is also important as a income structure. Is that there is nothing called a foolproof contract, but it is important you have a fair contract. Fair contract is always work in the long run. If you feel that there is a one-sided contract which is always in your favor, what is say for example, an employment contract. Okay. So you have all the in-house lawyers, what they do is that they load all the clauses which are in favor of the company and then prepare a detailed from 40, 50 pages each of the document. The employee who is going to join you has no options. He has to sign the document.
Yes.
But end of the day, you know that how enforceable it is. Right? So today, and people even don't know, post the termination of employment, the covenants are not enforceable. But the company doesn't actually listen to you. They say that like, oh, he cannot join a competitor, he cannot do this, he cannot do that. But the thing is that if you go back to the same contract type, these are not enforceable. So that's where I think what is important is to stitch a fair contract, which is reasonable to the other side, so that you have a long-term relationship with the counterparty to the contract, so that he listens to you, is also obligated to, he at least think of performing the obligation on his part. So that is also very, very important.
I think, sir, you raised a wonderful point of fairness, and I think very few people realize this aspect of being fair, especially as a lawyer, because sometimes lawyers are not seen to be the most fair people in the planet because of the perception that we have developed, perhaps built over the movies, I would say, if not in actual conduct. The second thing I think I must ask of you is that because you have headed so many companies in the past, and and your rich experience there, and you speak of fairness in a contract. Is there ever a dilemma? Because when you are with a company, the company has a mandate, and they say, look, for an employee, we have this particular contract to draft, and you have to have a non-compete clause, and you have to have other clauses which are favoring the company. And I'm sure with your approach of so much of fairness, you must sometimes pitch your own voice to the directors or to the other management, saying, look, this is not fair. How do you draw a balance between fairness and legality?
It's a very, very critical thing. But what is important is that as you grow along, see, it's not an easy question to answer in the sense. At least you need a voice, or you need to attain a stature for that, at least to say that at least the grip of the subject to be able to argue with the person who has authority, especially with a person commanding authority. You need a lot of grip on the subject, to ability to argue with that. The first thing is like not to rub anybody on the wrong side. It's important. It is nobody likes to listen that on the face that you are wrong. Nobody likes to listen. So what is important is that first understand. Let him take you through, walk you through the several things which the difficulties that his decision will be facing as you go along in the journey. So explain it to him what can go wrong, and explain to him how it cannot be mitigated. Then he will come to sense. There is no point in being brash and say that what you are saying is wrong. But an ability to walk him through the journey and say that if I agree to what you are saying, and tomorrow if it happens, that risk cannot be mitigated, because there is a judgment to that, and there is a past case which has happened like this, or there is a similar incident of being a competitor behaved like this. So there could be so many other illustrations which can come, so that he is composed. Then his mind, then he sees you as a threat in his journey, not as a competitor to him. So that is very, very important, especially dealing with people who are hiring, especially as an in-house counsel. When you are somebody, for example, a director or a senior VP, executive director, then there is no point in being arrogant, abrasive.
Very nicely put, sir. And the other I think, suggestion I think that you made is that when you're working, because I'm talking of not just your experience in GMR, but also your subsequent experience with Essar, with Punch Lloyd, with HCL Technology, you've been with Suzlon, you've been with Commission, so many other companies. and I want to club them together because of paucity of time start putting the questions. You said that when you are GMR, there are two things. One, you are pitching for different tenders with the government, and unfortunately, we all know that government is, be it a state or a central government, is one of the biggest litigator. They just want to drag sometimes people to court, and people sometimes out of their no choice left, have to file a particular litigation or court of law. So as an in-house counsel, because you're not just a legal advisor, you're also a business advisor to a company. And there is a very delicate balance with the government, as you rightly said, because you're liaising with people. You are having a good relationship with them, but then there are times when you just have to put your foot down as a business owner and say enough is enough. Sometimes we are being wronged. So how do you draw the balance, and how do you explain to the management that look, this litigation is inevitable, we have to go for it, or look, we can avoid this litigation? That is my first question, and then I'll come to the second question of arbitration versus litigation after this.
Yeah, I will answer that. See, what is important is that I think as a lawyer, in-house lawyer, you need to understand litigation is not your first option or first way of say your resistance, or say that your views are contrary to the other. Litigation is something that is a last option. But what is important is that there are several other effective methods where you can agitate yourself. There are internal mechanisms within the government where you can escalate these processes. So these are all need to be adopted and need to be exhausted. As an in-house counsel, no company wants to convert yourself as a litigating place, or nobody wants to get no company wants to get a name as a litigating company. So that is very, very important. So that, and litigation as a last option in your exercise has to be strategic. It needs to be strategic in the sense you are going for a specific goal. That's very, very important. What is that you want to achieve by doing that? If it is recovery of money, I think unfortunately today the scenario in India is that it's very, very difficult. If you are looking at recovery starting from a district court or a high court to several other places, one, the recovery is a difficult process by itself. The suit itself takes so many time. And apart from that, by the time you get a decree in your favor and then the ability to enforce it, by the time the money comes into your account, you have spent a substantial money, and then it is actually good money after bad money. I would put it that way. So that being the case, you need to be careful with what they do. And internally, it is not, nobody favors, actually, I would put the reverse. It is always better to sit across the table, recovery. If there is a possibility, use, I would say, something where there could be pressures which can be mounted to different directions or something. Where, of course, within the four corners of law, whatever you can do, you can do everything. But I think when you are taking it, you have to take the litigation as a very effective strategic. I would put it that. So there's no point in filing several litigation on the same subject. And it's not going to converting yourself getting into, because there is a lot of time which is being, especially as an in-house counsel and also as a company, spends a lot of time in reviewing this. There is a management time being. So when the management is spending time on things where it is relating to the cost operation, it is not being productive and forward. So it is not very productive. That being the case, we need to be very, very careful and evaluate 100 times before starting.
Right. So my question is, because we all know that litigation can be really time consuming. A lot of effort and resources are utilized, and sometimes wasted on futile litigation, so as to say. And arbitration has come up in the country slowly but surely, and there is always an attempt by the governments, by the authorities to make India more feasible for business? They say, it's conducive, things are changing. But do you think in the ground reality is such that people are still open to arbitration in India? Because I still see a lot many companies preferring a foreign arbitration, or the seat to be different. So what is your take on that? Preferring litigation over arbitration, number one. Number two, sometimes it's also seen that an arbitral award by and large is challenged, eventually in the court, and then again we are back to the old rut of getting stuck in litigation. So what is the solution to that?
I think what is important is that, see, right now, yes, one part I agree, yes, arbitration is a mechanism which need to be adopted. There is no two views on that. Litigation cannot be the way forward because there is too much time being spent on it. But India still hasn't asserted itself as a preferred place of arbitration. That's a ground reality, let's face it. And the Supreme Court has not very kind to that atmosphere. It has not in the past, especially considering the past of conflicting judgments and then creating room for confusion there. And it has not been very kind to that area. That being said, I think still the mindset of people, especially when you are in a place where you are interacting with foreign parties as a counterparty. So it is very, very difficult for as an Indian company to agree to make them agree to Indian arbitration unless you are in a very predominant position where your ability to negotiate the document is your where the other party sees you as a necessary evil. I would put it that way. So that unless otherwise, say for example, if you are a developer, your EPC contractor sees you as a necessary evil. You have to get this. So he has to agree whatever you say. See, fine. But what happens is that if the other party, the counterparty is almost equal to you, then there is definitely a resistance. So and you need to do a lot of groundwork need to be done where you need to reach a finality on the arbitration. See, still there are wrong things. Say for example, there was a recent judgment on the fraud aspect of fraud being committed in the arbitration. So there are several loopholes, or I would say gaps, which are there in the arbitration process by itself. So it will take some more time, but I think it is a question of where I would say that a student scoring from 60 to 100, I would put it that we were there closer to 90. I think it's the last mile connectivity, which is taking a little time. But I think surely and steadily we are there. But we also need to develop few as credible as, say, for example, SIG or HCI. Some credible institution which can demonstrate we have arbitrators who are very fair and, and deliver the awards in time, and the awards covers are comprehensive. See, but unfortunately, today the scenario is that the arbitrators award are not tested. In the sense, say it can be as vague as anything, unrecent, non-recent awards, and one-line awards. So they are facing with so much difficulty. But what is important as the institution develops, there is a system of internal checks and balances there, so that the award goes in and only the credible arbitrators are on the panel. So these are all there are for which we need to develop an arbitral panel which is capable, and then there is a paucity of subject matter experts. So today the scenario is that, for example, in India, especially a developing country like India, infrastructure requirement are huge, and most of them have government on the other side. But what is happening is that when it lands up in a dispute, what's happening is that the person who is sitting at the arbitrator have no knowledge of the conception of the procedure. He does not know what is a code chart. He does not know what is a CPM, which is a critical path method. Okay, what he does not know what is the bill of quantities. There are so many things which are very, very critical in the construction industry. So you have somebody and then half the time is wasted on coaching that person. And I don't know how much of that gets digested and comes out in the award. So what is important is to develop a pool of arbitrators who are competent and who are ability or subject matter experts who can develop, who can provide a very comprehensive and a convincing award, which passes the test.
I think
I
so.
think we have to go a bit far, but I think there is a lot of work to be done.
And I completely agree with you. I think there are a lot of gaps that we have to plug. But I think having said that, this is a common complaint across the board. I mean, people that I also meet, they say that sometimes it's you're coaching a person trying to make them understand because there are so many technical issues involved. I don't know, but perhaps just something to suggest. And because I mean, this suggestion. Let me ask you a question, and then I'll put the suggestion. My question is, how active is your internship program? And why I ask you this is because so many young students today, or people who are graduating out of law school, have a lot of inclination towards being either an arbitrator or an arbitration counsel. And they are very seriously pursuing this as a career. They are participating in a lot of national and international moot courts with a core focus on arbitration. They know what different treaties and transactions the world over are. They're very serious about this approach. So, is there an internship program in the companies today for young lawyers or budding lawyers to train them to be good arbitration counsels? Because in future, if they become or they assume the role of an arbitrator, the whole exercise of coaching somebody or wasting valuable time or billable hours of a company goes down. And the other suggestion would be because many times when we see a lot of either members or bureaucrats or retired judges donning the hat of an arbitrator, so the traditional wisdom of being from the litigation background and then donning a hat of an arbitrator and understanding these technicalities, there is definitely a bridge which needs to be gapped. So how do we find a institutional solution to this? But does it start from law school level? Do the law schools need to have partnership with companies like your company or with GCs or different companies or a common platform where we teach people the art of arbitration or the art of alternate advocacy?
Well, I think you have raised a very important question. In the sense, say arbitration. See, I know because I come from an infrastructure background. For 15 years I've been on infrastructure and construction because infrastructure a lot of construction thing. So that way, what happens is that I can speak with a little authority here. There is a huge gap in construction related arbitration. There is not many people who are around. And institutionally, if you look at there is NICMAR, which does construction. But it is not, it is more of a construction management and it is not a regular arbitral institution, I would put it that way. There's a huge difference. But what is important is to also understand the intricacies of construction. The similar thing goes for a pharma or a biological thing, a company which is into pharmaceutical thing. It can happen to any other IT company or something. Unless you know the technicalities of that particular business, it's very, very difficult to ability to come. Say, for example, even it can be a Supreme Court judge, high level of bureaucrat, but the ability to understand the nitty-gritties and then come to the speed. Because a few things, for example, a force majeure in a construction industry is a huge thing as compared to something happening in any other industry. Because there are certain processes need to be followed. I'm giving you a flavor of just another example. So, a force majeure, if your notice is not proper and it cannot be as per the contract, it cannot be a force majeure for that matter. Be that it is like no, in the public domain, it can be demonstrated as force majeure, but the notice is not as per the contract, is not given, then it is a constructive terminology. So, somebody coming from a different background and trying to say that this is what it is, especially considering the arbitration is a very informal way of deciding. Okay. Then in that case, it is completely wrong from a contractual perspective because under this authority only is being appointed, and he cannot go turn against the same contract. So that way, the nuances has not been clearly picked up by, I would say that the bureaucrats or the different. I think what is important is one, there are specialist lawyers, of course, there are there in the construction industry, and there are of course GCs. I think there need to be a joint exercise to develop the impact. I think as a person who has grown in the industry, I have an obligation to give it back. I agree with that. But there need to be a form created because what happens is that there is also the importance of the confidentiality coming in and everything. And especially a company like me right now, we don't have any litigation for that purpose. Okay, to be very honest. So that being the case, see, what is important is that we don't, our focus has been how to avoid litigation rather than how to get into it because we don't make money on litigation. We make money on several projects, not on litigation. So that being the case, yeah, but that being the case, your ability to avoid arbitration is basically because you know how arbitration is run, so that you don't make that mistake of this thing. Your contract uh, knowledge is good. If you're good, then it doesn't harm you land in arbitration. If it is bad, again, I'm coming back to the same answer. You need to have a good hang of contracts and specific performance, of course, critical provisions of the constitutional law. These are so sacrosanct, so sacrosanct. Without, you may have tax laws and all. These are add-on, good to have, like property transfer of property act. But if you want to be a successful in an infrastructure industry, the baseline is contracts act and specific performance. And apart from that, any add-on is welcome. You can be good in FEMA, you can be good in RBI rules or whatever. These are all good to have, but the baseline is foundation is contract. But the thing is that I think where it is important is to focus or to have an industry experience mixed with the contract. I think that will give a lot of perspective to their study. Because study without reading the barrack, it can be beyond a point, it can be good. But with a perspective, it makes it so interesting where you can build upon.
So, sir, with that, I come to my next question. In a lighter vein, I must ask you because many times a litigator like me, a litigating lawyer, feels like that in-house lawyer, though most of them are our friends, and we are hailing from the same fraternity. We do believe that once the lawyer becomes in-house and goes to a company, chances are that our billables go down. So, how does the company decide on its legal budget to allocate to a particular dispute? Is it something like CSR, whereby law you have to keep a particular percentage for CSR, or does it like we will see what type of litigation we are entering into, and by that measure a particular fund is kept for litigation? And number two, because a lot of transition over the years has happened from law firms to in-house, how easy or how difficult does it become then to find a lawyer to argue your matter in a court, either from a law firm or from a chamber practice?
I would see one, you asked about the budget. The budget, if good company or say that there is something called the zero-based budgeting. So zero-based budgeting is that every year starts on its own. There is nothing called a precedent over there. So the last year is not an indicator of the current year. Right. So you take the current year as such. You visualize, you know that you have a business budget. Because as a GC, I am entitled to the peer being there from the technical side and also the marketing and business development. Then I have the CFO, all these people. I have the thing where I sit along with them to discuss the business for the year. That being the case, I know that what is the company is going to do. Okay. So the company is going to do, okay, the company is going to get into a joint venture. You know that what the joint venture agreement is going to take, how many reviews it is. So again, you know who's going to be the counterpart. So who's how he behaves. So whether it will take 1 round, 2 rounds, 5 rounds. So depending on that, you mentally prepare it in the sense. So you know that what are all line items which are required to make a budget for it. So the company is going to bid for this much number of projects. You know that. And there is a, by your past experience, you also know out of this, if 1, 2 cases go wrong, so whether we need to file a litigation. So how much this litigation will cost. So you know the lawyer who is going to assist you. That you have your own relationship. Yeah? So you know that typically how much it is. So this is how a budget is made where you are, see what is important is that your ability to plan well is reflected. By end of the year, there should not be any gap between actual budget uh, versus actual money spent, which is, should be closer to 10% or so. See, that way your ability to think it. Otherwise, what happens is that you can't generally assume that whatever gets done in last year will get repeated. Because the business grows, you have to accommodate for its growth. Because if there is a growth in the business, you have to spend more on things. It's not necessarily in litigation, but on the more, say for example, the company may acquire other, like there is a M&A for which that to do the transaction, to do the due diligence. There is no point in creating a separate M&A team because this is the one-off activity. It's not a regular thing. So you engage an external lawyer to do the due diligence when there are transaction documents. So for which this is the one-off activity. So that way you know the budget, you know how to. What is important is that how do you control the budget? How do you make your lawyers really work with? That is what GC work is all about.
Right. So coming to my penultimate question, because you have donned so many hats over the year, you have been a pioneer in the legal industry by being the first legal officer of so many companies, from the early liberalization to date. One, how is the transition that you have seen over the years? What does the future hold for the future lawyers who want to be in-house counsel? And what will be your advice to them? How can they enter as in-house counsel? Why I ask this is also because so many young lawyers who are watching this episode would be interested to know how to make inroads. Should they join a firm first? Should they do some litigation? Or should they become in-house? What would be your advice?
I would give a little, especially if you can afford, to spend at least a few years in litigation, especially in court practice, whether it could be in litigation or in the sense it is better to spend a few years in court to understand how the things go bad. Because only the things which ends on the wrong side lands up in court. Okay. So understand and especially learn from that experience what mistake we should not create there when we are especially when intending to on the in-house thing. You know that whatever mistakes, especially because of this background, I'll say that a good litigating counsel is also a good contract drafting counsel because he knows that how things can go, right? So that he ensures that these are all. And apart from that, it is also important the youngsters to understand the drafting perspective, make the draft, make the contract simpler, so that at least tomorrow they are not cutting their word because a word extra in especially in process of contract, a word extra is always better. So there is no need for an extra word there. So that being said, it is very, very important that you have a right contract which is make for yourself. Don't take it from somebody else. That is another. But Apart from that, today the youngsters who are coming in have the great ability to quickly adapt to the environment. That's very, very commendable. But what is important is that it is also it is need to understand this is the laws and it's a continuous learning process and need to update it. And it is also important keep the reading habit of reading the law journals or reading the bar act frequently improves gives a different perspective of the same law, which you couldn't say for 10 years back, you couldn't do that. If I read the contract act today, I get a different perspective altogether. What can be done new from that? See, that way, that will every day your perspective on that changes. So I think youngsters need to read the Barak frequently and read the updates on them and keep the reading habit very regular. At least read a few pages on a regular daily basis will go a long way good. And more important is that make a note of your own thing, which is very, very important because we feel very confident of remembering everything. But unfortunately, that's not the scenario. And keep a notebook always in your side. Make a note of whatever things which can, the legal things which can be in your favor or against you, okay, which can help you. Take a note of it. It can down the line, it can one day it will help you or it will pay for all the whatever efforts you have put into.
Thank you. Sir, as a concluding remark, as a last question, I must ask you this because with such an enriching experience that you've had, I do believe that a lot of stress comes your way, and also the team, that you supervise. So for our young listeners here, and when I say young listeners, I always mean to say young people who are young with age on their side, and also who are young at heart and young in their mind. So youth is not just just physical attribute. So how would you advise them to tackle and handle stress? Because these days mental health issues, especially during the time of the second wave and other things, we are all homebound most of the time, and work stress is there. People are working from home, and more. I think the timing have elongated, if I must say so, because most of the time we are spending our time before the computer screen on the smartphones, etc. So for young lawyers, young listeners, and people generally, how would you give a talisman or a mantra to handle stress and have a good mental health?
See, stress, say for important, stress is something I think the more important is have a good physical exercise for everyone. That's very, very important. Especially for lawyers, we take it for granted. So, a physical exercise will do a lot of good starting from the early days. And a good diet, which is very, very important. One, do more on that. Then apart from that, I think the social media, the news, and the journalism today is not doing a lot of good for you. So I think it is important you need to put your wisdom to it and see that limited to the minimum consumption where you need to know certain things from an information perspective. Yeah, spend time on that, but other things because it's not going to help you. It's not going to just I'm going to add you to whatever. At least I'm talking of the present environment. So it is important, yes, if it is social media, very important where it is good. But at the same time, you need to allocate. People know how to get in, but they don't know how to get out. That's unfortunately the scenario is like typical uh, Mahabharata scenario.
Yeah, it's something like the Chakravyuh.
So
You only know the way in, you don't know the way out.
you don't know the way out, and that has been the scenario. What is important, I think, slowly, if you can, people can develop the reading habit. That can be a good long way going to this. And I understand it is not same for everybody because fortunately somebody who have meal on the table for somebody may not be there. But it's like what is not way to, I think, develop your skill sets, develop which industry needs what particular skill set. This is a good time. People can approach GCs. There are the GCs also today. Unfortunately, they are working on it. they have more time to spare. At least today in office, they are in a very restricted environment where they cannot have interaction. But at least now they can interact, connect with them, understand what is their. So it can you can be a even for the GCs I am saying you can be a mentor to people. They can do that in the time. Because this is the only way we can give back to the society or to the profession. So that way there could be a connect could be made. Then it is all the more important there is always somebody who if not I have I can refer to somebody. See, at least on merits, they can look at it and take that person. So these are all things which can be done now. There is a lot of time available for people. Use it productively and use it in such a way that you don't think of anything else which is negative. How to do that? And this is not the time to be negative. This is the time to be improve your skill set, improve your reading habit, improve your health. That's what.
Thank you so much, sir, for these wonderful words. The takeaway is don't be negative. Definitely don't test positive for COVID, but be positive in your mind. I think that is very important. And maintain a healthy diet, maintain a healthy regime. I must, sir, thank you while concluding this program for sparing you valuable time and coming onto our platform. And I do wish you all good health, success, and prosperity in the times to come. And thank you once again for being associated with the channel for this wonderful episode. And for the viewers here,
Thank you, Jayant. Thank you for everything. Thank you for
and we should always appeal to our guests and to our viewers also that if you do like our channel, then please kindly like, share, and subscribe so that the legal awareness program that we have started with a small attempt to create awareness in the world must reach to as many people as possible. With that note, sir, I take your leave and thank you once again and good night.
thank you.